Okay, but I thought that was Judge Quattlebaum's question. Had the IJ said, what if the next sentence was, or what if the sentence is modified? So it's the record in this case shows some risk of harm from each possible source of torture, and for several reasons, which when combined might be greater than the sum of the parts. But even when considered cumulatively, I just don't see it. Is that enough?
Well, she did not do an analysis that substantively engaged with the meat of what these reasons looked like in terms of the actual threats. And in particular, the fact that the gang is already considering the sum of Mr. Kerr's identities and why they want to target, and have already tried multiple times to shoot him and threatened him repeatedly, saying these combined reasons in the same breath. Batty man, you're a thief, you're dead.
But that's exactly what the IJ said, that for those two reasons, the gang was after him in America, and she did not find any significant possibility that that would pose a threat in Jamaica.
She did that analysis of looking at it in America, but the question is whether in Jamaica, Mr. Kerr will have a more likely than not chance of torture. And because she did not do that analysis in connecting to what had happened in Jamaica, as Dr. Blake's report states, directly bears on how he will be treated in this very small country, where the gang is very well connected with the Jamaican government and police. It was not a meaningful analysis of how those risks will occur in the real world. And that's the purpose of CAT. That's the purpose of the implementing regulations, as this court repeatedly said in Rodriguez-Arias and in Ibarra.
Thank you very much. I think you've got time on rebuttal. Thank you.
Good morning, Your Honor. May it please the Court, Lisa Mercia of the Office of Immigration and Litigation for the respondent. This petition for review should be denied. Mr. Kerr primarily argues that the agency failed to consider in aggregate the sources of torture that he alleged he faces if removed to Jamaica. However, the agency's decisions here clearly acknowledge all of these assertive sources of torture: his former gang, the Shadow Posse, other Jamaican gangs, civilians in Jamaica, and Jamaican authorities, as well as the various reasons that he's put forward he may be targeted: his former actions with the gang, his sexual orientation, his status as a deportee, and his former gang membership.
So, counsel, if I could just interrupt you, I'm sorry to do it so early, but I think it's fair to say that whether certain things may have been left out or not, the agency talked about many of the risks, and then it said I consider them in the aggregate. But we have an argument here that just to for explanation, it's like 2 + 2 = 6 or something like that, and that wasn't addressed specifically. Is it your position that the aggregate statement, just the one sentence, is enough, or is it your position that that doesn't have to be addressed at all?
I'm sorry, can you clarify what you mean by not addressed at all?
Yeah, I'm just trying to think, or trying to see the government's position. Does it not have to address this compounding issue, this compounding argument of characteristics, or is it your position that just by saying I've considered them in the aggregate, that satisfies it? It has considered it.
Well, Your Honor, I think there are two parts to my answer there. First of all, in terms of the aggregation, in terms of what the agency did here in considering in aggregate, I think this court has made clear in Ibarra-Chavez that there's nothing in the regulations, agency guidance, that directs the agency to employ any specific methodology when considering and aggregating the likelihood of risk. So here, the question really is, did the board and the IJ consider all of the evidence? That's what's required under the regulations, and they did. What the petitioner is properly considered all of those things in the aggregate, the second question is whether or not the substantial evidence supports the agency's decision here. And substantial evidence does support that decision. There's nothing in the evidence that petitioner cites in their brief. There's absolutely no portion of the record that would compel reversal of the agency's decision here. The agency looked at all of the evidence. The IJ went through every single, I mean, not every single, I can't, but they certainly considered it. The IJ considered all of these claims of the petitioner and reached a conclusion on that basis. And after that, the question is, does the record compel reversal of that conclusion? So I think, so that's my first answer to that. I think the second part of that question is whether or not those two sentences are enough. And the respondent would say yes. I mean, that is, Ibarra Chavez specifically contemplated that when they say there's nothing in the regulations that the agency employed any specific methodology, that they have to put forth that they considered it in aggregate. And the cases that Ibarra Chavez cites in that are illustrative of that. They cite Airhead Martinez versus Garland, holding that even though the BIA did not make it perfectly clear that it was performing the aggregate analysis, on balance, the BIA said enough to convince the court that it did in fact find that there's less than a 50% chance that petitioner will be tortured by all potential sources of torture in the aggregate. And they also cited Hassan versus Rosen in the Eighth Circuit, which held that a separate or lengthy aggregation analysis is not required. It is enough that the record indicates the IJ and BIA consider the risk of torture in the aggregate. I mean, this is essentially...
Can I just ask a question about this? And I do appreciate that those cases say that, and we relied on them, and that Ibarra made really clear we're not talking about an equation or anything, and there's no particular methodology. On the other hand, we do have to review, not only the individual risk assessments, but also the aggregation assessment for substantial evidence. And I do find that it's sort of challenging to do that when the IJ hasn't explained her thinking at all. I totally understand from this very thorough opinion why the IJ believed that as to each source, and I think looking at all the relevant reasons, each source didn't add up to a likelihood. But I just have no idea how to review that last sentence saying, and also they don't add up to more than 50% when I add it all together. How do I review that?
Well, Your Honor, I think one of the ways to think about it is in the context of the regulation, the language of the regulation that says more likely than not. So the IJ here is going through each of the, whether he had gone through it in terms of reasons or he had gone through it in terms of sources of risk, he's going through each of these separately, which, the board and this court has said separately or in aggregate. So he's going through them separately, or she is. But they're going through it separately. The agency's going through it separately and saying, like, none of these individually would satisfy that standard, more likely than not. And they get to the end and they're saying, okay, if you look back at everything I just said, does that add up to more likely than not? And so you're looking back at the findings of the IJ.
So should I go back and try to put should I try in looking at the findings of the IJ sort of ballpark, the IJ seems like the IJ thought maybe 30% for that one. I just don't know, without doing that, I don't know how to figure out whether they add up to more than 50%. I thought the IJ here gave us at least some clues because there were some sort of ballpark estimates. There was one where the IJ says, basically this isn't even close, well below 50%. A couple where the IJ said it's not even significant, minimal. So maybe you can look, or am I supposed to look for context clues like that? I just really don't understand concretely how to review the aggregation finding if the IJ doesn't explain it.
Well, I believe that the IJ does explain it, though. When it goes through it separately, and then it says in aggregate that also does not add up to more likely
So maybe to follow up, I mean, is the argument we're dealing with, the kind of whole person argument, really an aggregation question? Because when we've really been talking about it in other cases, it's where an agency didn't consider one of the factors. And we've said, no, you can't just pick out some of them. You have to consider all of them. And under that sort of analysis, not the district court, but the agency, probably does that. But there's this additional argument that, together the sum is greater than the whole of the parts, which I'm trying to figure out, is that really an aggregation argument, or is it just another argument or another piece of evidence? I don't know if that's a distinction without a difference, but it just seems like we're talking about something different than we've talked about in our other cases. And I'm trying to figure out how to characterize it to see, I don't know if the standard review is any different or anything. I don't know if that's kind of more of a comment and wonder. Do you have any response to that to help me?
Your Honor, as I understand Petitioner's argument, he has two sort of arguments. He's arguing that the aggregation analysis was incorrect here, which the respondent disagrees with, obviously.
Right.
But then he's also arguing what I believe is an evidentiary argument, saying that the board did not, or the agency did not look at all of this evidence regarding risk sources, whatever, is before the agency, and that they did not correctly analyze that. And here, I believe the board addressed what Your Honor is talking about, saying that the agency addressed it as he presented it. That he said, I am a former gang member. I had problems with my gangs where I stole from them. I am an LGBT person. And he put forth all of these claims. And he sort of laid out that he would be at risk because of from these sources in different ways. And that's how the board said that the agency analyzed it here. Because he never, for example, he might be at risk from I'm sorry, I would have to look back, but I think that the example that the board uses is that, he would be, I'm not going to find the exact language, but the example that the board uses, I believe, is that he would be at risk from the Jamaican civilian population as an LGBT and a divorcee, possibly, but he wouldn't necessarily be at risk from other Jamaican gangs as a deportee. So that's the way that the IJ analyzed this evidence and looked at the evidence in that way. From how I understand Petitioner's argument, he's saying that somehow that the agency didn't look at all of these factors cumulatively. But the respondent would say that if looking at the agency decision is just flip sides of the coin on how they analyze this. They're looking at the sources, they're looking at the reasons, and even though they're organized by sources, they're certainly looking at the reasons as well. So he doesn't end up by saying that somehow that that they're not looking at everything is simply incorrect. And there's nothing in the evidence that would compel any reversal of the agency decision here. I think that's the most significant point here. That the petitioner has the burden of proof under the Convention Against Torture to establish that he's more likely than not to be tortured in Jamaica. And he simply cannot point to any evidence that says that this somehow, all of the reasons that he's putting forth, if you want to put it that way, the reasons, this sort of compound structure that he's put forth as being his identity, puts him more likely than not at risk. And the agency did consider that.
Okay, well, what about the IJ's statement, counsel, that the gang may have a problem with cursed sexuality? Now, how is that sufficient to address the likelihood of torturing Kerr based on his sexual orientation, coming from the gang, coming from civilian society, perhaps coming from other gangs? the different evidence that the IJ considered. The IJ just said they may have a problem with his sexuality. Well, that's kind of a very non-substantive statement, isn't it?
Well, Your Honor, I think he's saying that, I believe the section that you're looking at is where he says that under fear of torture by the shower posse. And so there, as I think was previously discussed during Petitioner's argument, the IJ acknowledges that with his history of the shower posse in the U.S., that some of the shower posse members in the U.S. had a problem with him as he defied the gang in some way, whether he stole from the gang, his relationship, his LGBT relationship, or for other unknown reasons, but that didn't translate to Jamaica. And then the IJ looks at fear of torture from other Jamaican gangs and looks at whether or not that would be sufficient to show a risk of torture. And then he also looks at the treatment, society's treatment of the LGBT community as troubling. And this is something that the board acknowledges as well. So looking at all of that in aggregate, looking at the risk of torture on the basis of his LGBT status, his former gang status, the fact he stole from the shower posse gang, the IJ is still saying that is not enough to show a risk here. That it's more likely than not he would be tortured. I mean, as the board and the IJ says, Jamaica in general does not have a good record with LGBT status people. However, is there anything in this record that tips that more likely than not? And the question before the court is, does the record compel reversal on that basis? And the petitioner doesn't point to anything here that would compel reversal, that the board and the IJ didn't look at. I mean, that is essentially what Ibarra Chavez goes to when they're saying that, when they cited Irheta Martinez, which just for the record, it also cited Mindai, where it's saying that, the question of substantial evidence here, again, is that the record compels. The reviewing court may not overturn the agency's factual determination unless there's compelling evidence. And there's no compelling evidence that the petitioner here has presented that that the agency necessarily erred or the agency erred in its factual findings here, or that they erred in their analysis and evidence. So, to the extent that Mr. Kerr argues that the agency did not consider certain risks of torture or evidence in the record, this is refuted by the immigration judges and board's reasoning. The record doesn't compel reversal of the agency's conclusion that Mr. Kerr failed to establish eligibility for protection under the Convention Against Torture, and for these reasons, the court should deny.
Counsel, I'm sorry, you were just concluding, but I want to, I'm still wrestling with this. Just assume hypothetically that I think when I look at the IJ's opinion, that substantial evidence supports sort of the four preliminary, what I think of as four kind of preliminary findings, that from each of these sources, potential sources of torture, and for the reasons as presented by the petitioner, you don't get over 50%. But I'm still trying to figure out how I know whether there is substantial evidence to support the further finding that even when you add them up, you're not over 50%. And so let me ask you, what if the IJ had said, as to each of the first four, like, boy, it's really close, but I'm putting it at like 49% for each of them, and then said, and also in the aggregate, it's not over 50%. What would I do then?
Well, Your Honor, first of all, I think that the government just be putting each of them at 49%.
No, this is a hypothetical. That is not what the IJ said here. The IJ was very clear that she thought it was well below 50% on the first one, and that the others seemed to her to be quite minimal, or at least one of them did. Ourselves in trying to figure out, I don't know, how likely is each one of these? How else, if we don't do that, how can we review the question of whether added together it gets you over 50%?
Well, again, Your Honor, first of all, I think that this court explained in Ibarra that the statistical model doesn't necessarily work because you can't necessarily look at each of those
Right.
separate individual claims or each of those individual sources and say it adds up to 50%. So in some ways, what the IJ is saying when they're looking at it separately is they're saying, would this particular one, would this say more likely than not? And if that does, then, then if they've shown separately, one source would show more likely than not, and that would fulfill his burden. But then when they're saying that I've looked at it all in aggregate, they've looked at their former findings, and they said that looking at all of these findings together, this still doesn't sustain the burden more likely than not.
But to follow up on that a little bit, if the nature of the opinion in going at them issue by issue didn't give us, context that, hey, these might be near 50% or more. I mean, it sounds like what you're suggesting is, we read the opinion, we read how the immigration judge and the board talked about the various arguments, and in light of how they do it, it's, that we can look back at the statement about the aggregate is not more than 50% too. In this case, that might be hypothetically easier to do than if someone, had talked about the way Judge Hare said that, oh, this one issue might by itself almost put you over the top, but I find it's not quite there. Then there's like maybe an internal conflict. So I guess my question is, do we just look at the opinion as a whole and see if what is said about the individual pieces kind of matches up with what's said about the aggregate analysis?
Well, Your Honor, I think it's a combination of both looking at the question of, did the agency do the aggregation analysis correctly? That's the first question here. And, did they cite the correct law? Did they look at the aggregation? Then, as Your Honor,
So I'm sorry, counsel, I want you to finish, but so I just want to, you said, did the agency do it correctly? But what you mean is, did they do it? Like, okay.
So, did the agency do the aggregation analysis? And here they did. They cited Rodriguez Arias, and they said, we are looking at this in aggregate. We looked at all of these facts and done it. After that, the question is substantial evidence. The evidence is there anything in the record that would compel reversal of the IJ's decision that it's more likely than not that this person would be tortured in Jamaica? And that's the second question for the court. And here there's nothing in the agency's analysis that would reverse on the substantial evidence standard.
All right. Thank you very much.
Thank you, Your Honor.
Your Honors, the analysis that we're seeking doesn't require any kind of mathematical methodology or statistical approach. If instead, for example, Mr. Carr had only been bisexual or a thief, there would have theoretically been X level of risk. But that's not the case here. Because he's both of those things, those risks are compounded, just like the gang compounded these reasons in threatening him. And that is not what is in the IJ's analysis. It's missing here. How those compounded effects of his identity are a real-world risk. The gang is already doing that analysis and threatening him for all those things at once. So in order to reflect what the actual risks would be to Mr. Kerr in Jamaica, the analysis that the IJ does needs to reflect that. And that's consistent with Rodriguez Arias and Ibarra Chavez in saying that all sources of risk must be considered. This court said in Rodriguez Arias that failure to aggregate all sources of risk is a legal error that's subject to de novo review. And that's something.
Can you just tell me where specifically, under which sources did the IJ fail to consider all of the relevant characteristics?
Yes, Your Honor. Under in particular, the threat from the shower posse.
Right, the shower posse.
His sexuality as well as from other Jamaican gangs based
Other
on
Jamaican gangs.
sexuality,
Okay.
and from the Jamaican civilian population as a former gang member. And those reasons were not discussed at all. in any
Okay,
kind of-
so, I mean, this may go back to Judge Quattlebaum's question. I'm just struggling with this argument about like taking the person as a whole and the compounding cumulative nature of the reasons. It really comes, what you're really saying, right, or are these two separate arguments somehow that I'm missing? It seems like what you're really saying is I can go through the IJ's opinion and under each heading, fear of torture by Jamaican gangs, fear of torture by civilians, and fear of torture by the Shower Posse gang, you're just saying there's some evidence that the IJ didn't look at here.
So we have made an argument about ignoring and misconstruing evidence, but we've also made
But
it's related but different argument on aggregation.
Okay, how are they different? I don't understand how they're different.
So within the aggregation argument, there are two problems here. First, the IJ did not really discuss at all in any kind of meaningful way those reasons that I've described, the sexuality from the Shower Posse and other Jamaican gangs, and from the Jamaican civilian population based on, and police based on being a former gang member. And also, she failed to discuss how these reasons compound each risk from each entity. And that has an impact on the final conclusion that she reached and makes it not...
Well, right, if she doesn't consider them, then she doesn't aggregate them either. I guess I'm just, maybe they're different arguments, but they seem like the argument that they weren't considered at all sort of subsumes the argument that also she didn't do it in the aggregate.
Well, she can't compound them if she doesn't consider...
That's what I'm saying, right.
So they are interrelated. However, the failure to consider the cumulative effect, I think, really bears on...
But are they more than interrelated? What if I thought, just hypothetically, that when it comes to, say, the Jamaican population, the part where the IJ talks about how deportees are often shunned as undesirable criminals, that sort of covers the gang thing. Like the reason they don't like deportees is because they are often gang members. So if I think that the IJ did consider that in looking at fear of torture by civilians in Jamaica, then I probably also think that the IJ aggregated it when the IJ said, when I look at all of this in the aggregate, I'm still coming out the same way. Or do you think even if it was considered, it needed to be specifically mentioned over on the aggregation side?
So in terms of the legal analysis required for aggregation, I think there has to be a discussion of what those risks will really look like. And that transcends simply what the evidence is and how that's interpreted, only in discussing each piece of evidence or another. I think it's really about engaging with the risks as they will actually occur. And the evidence is certainly part of that, but all of these evidentiary factors do bear on what the real risk will be to Mr. Kerr. And by failing to actually discuss, she discussed each of these risks, each reason in a separate subsection in each entity. And that is breaking things down into these silos.
Honest, but if she didn't do that, if she had just said, look, I've looked at everything, and in the aggregate, it's not over 50%, and I mean this with full respect, I assume you would be here saying, how can we review that? She needs to go through it and explain to us how she calculated each risk, right?
She does need to do that analysis. And just having one sentence at the end saying, I've aggregated everything, is not consistent with providing a meaningful basis for review of the agency's decision. And so that's why the decisions that the IJ and the board provided in this case are not legally sufficient in terms of doing that aggregation analysis in a meaningful way.
Great, thank you very much. We are sorry that we cannot come down and shake hands as we normally would, but we very much appreciate you being here today, and thank you for your assistance with this case.
we're really looking at the connection to the incident itself. Of their 585,000 claimed damages, about 330,000 of that can be directly attributed to Florida. So those damages Florida law should apply to those damages.
So you want us to divide them up as opposed to doing, I think what Wells ended up doing was saying, what you said, yeah, it can be hard, but they didn't do it. They then said, do the most significant relationship.
Right, and I think in this case, whether you look at it under, and that's why we argued that in our brief, is whether you look at it from the Wells perspective, you can say what damages were caused in Florida, and it was fairly simple. The documents that were produced show which damages were caused in which IBank, and so it's not that difficult to figure out. But even if you do the substantial relationship test, why is it Maryland in this case? What connection, especially in the strict liability context when we're talking about a tort, what connection does Maryland have to that tort? Whether the place of the injury, the last act that caused that tort, and it's not Maryland, at least not the factors of the court side, which would be like where Maryland signed the purchase orders. Like that has nothing to do with strict liability in this case. It's where the contamination occurred, or where the negligent acts occurred, and that's why we believe, with respect to the choice of law for strict liability, it would be Florida, it could be New York or Georgia, and in all of those, the outcome would be the same. And another reason why it would be important and why choice of law matters is for the economic loss defense, because while they all have an economic loss doctrine, they differ from Maryland with respect to that public safety issue. And so it can be change the outcome of this case depending on which analysis you use for choice of law.
I got one more question. I'm sorry for belaboring this, but does choice of law apply to the prejudgment interest question? No one argued it, but Maryland's prejudgment interest statute's pretty different than the ones I'm used to, but no one argued that for some reason.
I didn't argue that. I've never researched it, but if for trials that I have in the case where I'm sitting, we always use the law of where the case is pending. I don't know if that's correct or not, but that's why it wasn't.
Okay, thank you.
Thank you.
May it please the court. My name is Kelly Lippincott. I'm counsel for Stratus Healthcare, LLC. There's three sections of the joint record extract that I wanted to discuss during the course of my argument. It all appears in joint exhibit volume 2, and if it's broken into parts, your copy would be part B. First section I want to talk about is on pages 816 to 818 of the extract. The district court erred in granting summary judgment in favor of Carolink on strict product liability, breach of implied warranty, and breach of express warranty. In this case, the sealed container defense shields Stratus from liability. Stratus received Jerry Care eye wash from InSource in a sealed container, and a picture of that sealed container appears at record extract page 816. That says on its face, it says that it's Jerry Care eye wash sterile eye solution. That is the documentation, or that's the label directly on the packaging. And then if you go to...
But Stratus made its own express warranty, didn't it? It repackaged the document and made its own express warranty that this was sterile unless opened?
That, Your Honor, I would like to direct you to the next section of the record extract. And that's at Joint Exhibit Volume 2, Part B, pages 810 and 811. Those are the pictures of the custom Stratus compiles. One is for TBI ocular recovery combo packs, and the other one is for posterior pole recovery packs. And those are the complete packaging that the consumer receives, that has all the different items that are compiled by Stratus and placed into this packaging. And then there is a index listing what the items are inside those packs, and that's the white piece of paper that you see on page 810 and 811. Now, if you go to 813 and 814, those are focusing in on those pages, the blow-up of those pages that are come inside the packs. And those simply list what the items are that are contained in those packs. And that including the eye wash, the sterile eye wash. That is what Jerry Care calls their product. That is the item that is included, one of the main items included in both of those Strati packs.
But why doesn't council, aside from what's under each of those numbered items, down at the bottom under the barcode, in both the custom, in both versions, it says sterile unless opened or damaged. And it looks to me like that's applicable to the whole deal.
The testimony in this case explained that there are different kinds of Strati packs, and sometimes the Strati packs include two different types of items. There are items that are compiled by Stratus and then sterilized. So the exterior of the items are sterilized. There are other items that are just added into the pack, and once the pack inside is not sterile. For instance, you see that with the custom Strati pack for the TBI ocular recovery combo pack on page 810 and 813. It lists two columns. One is a column of sterile components, and the other is a list of non-sterile components. And underneath that, the sterile eye wash is referenced under the non-sterile components. So Stratus is not sterilizing the outside of the pack, or outside of the Jerry Care eye wash bottle, like it does, but it does do that sterilization product or process for some of the items that are contained in the pack, and that's why you see a list of sterile items and a list of non-sterile items. The non-sterile items, like the Jerry Care sterile eye wash, is not sterile on the outside of the packaging of the bottle, but the sterility of that eye wash is based on the product that was received from Jerry Care, that was marketed and identified, described, and labeled by Jerry Care in a sealed container as sterile eye wash. There was no warranty made by Stratus as to the sterility inside of that bottle, and the language that you see on those labels, the outside index of the items contained in the Strati pack, is describing what the product is. The product is sterile eye wash. Only in this case, it ended up not being sterile, but that is not from any action on the part of Stratus. That is a fault that has been assigned to.
Well, what about the language that we've been talking about, sterile unless open? They didn't have to make that representation about the contents of the Strata pack, but they did. So,
And that's referring to the entire Strati pack. If you are, when you open certain sections of the Strati pack, that has gone through a sterilization process. But the eye wash itself, the items inside, for instance, a gown, gloves, those are sterile until the pack is opened. When they are packaged, it is a very rigorous process.
right, I understand all that, but why isn't that a representation as to the product?
It is not a representation.
Why?
As to the eye wash, because the eye wash is, well,
As
but
sterile.
also, which is the name of the product. I'm not sure how they can,
I mean,
guess
you're
if
just
they
putting
would've just said it was eye wash,
Right.
Well,
and not use
I
the
mean,
word
you,
sterile, that's from the front of the label.
Well, is
That
this,
is how Jerry Care describes its own practice. Sorry.
oh,
No.
I'm sorry.
go ahead, Judge.
You go.
Well, I hear you. You have some arguments, and they may be good ones, I guess. But I mean, you got sterile in at least three places on the label that y'all prepared and sent with your product. And it seems like you're trying to say, well, we didn't really mean it, or we didn't mean it for everything. And you know, I hear you. Maybe that ends up winning, but.
I'm sorry, I would agree with Your Honor if this was a situation where they undertook to include sterile eye wash in the Stratton pack. But instead of getting sterile eye wash, they got, I don't know, re-wetting drops, or they got some other saline solution that maybe wasn't sterile and stuck that into the pack. But what they got was a sealed container from Jerry Care that was labeled and described on the labeling as sterile eye solution.
Right.
And that is what they put on their packaging. And their index for this package was to just describe what was there. And they used the words that Jerry Care used simply to describe the product. And they were not making a representation or a warranty. They couldn't warrant it. They did not control the packaging or the manufacturing of this product. Jerry Care did.
Thank you. You've got, I think, some rebuttal time.
May it please the court, good morning. My name is John Bourgeois, I represent Carol Inc. And I had trouble preparing for this one because I figured there'd be a lot of questions from a lot of different directions. And I feel strongly that Judge Blake got it right in just about every respect, including choice of law, including sealed container defense, including economic loss rule. I'm going to take my cues, I suppose, then from the questions I've already heard. I don't have a set presentation. Part of me was going to say I'm not going to say anything, but I'd be happy to answer your questions. I do want to respond at least to some of what I've heard. I think, Judge Keenan, you have it absolutely right. That the Court of Appeals of Maryland, like most courts and certainly most appellate courts and certainly most appellate courts of highest resort, use words carefully. And when they use the word purely in the economic loss context, when they use the word solely in the economic loss context, they do so for a reason. And I think that the reason is this, Your Honor. The damage to property, or personal injury, but in the property context, caused by a defective product, a damage to property other than the product itself, is different. If you only have a defective product, then you don't have the benefit of the bargain. And so your damage is purely economic. You replace that product. But when the defective product itself injures a person or damages property other than the product itself, then that is a trigger to a new paradigm. And if you can point to damage flowing from the property damage itself, consequentially, caused by this defective product, then you no longer are arguing about pure economic loss. You're talking about economic loss accompanying property to damage.
So counsel, it sounds like you're saying that I was trying to figure this out through the questions earlier, that if you have damage to the property other than the product itself, here we have damage to the tissue. Is it your position that if that occurs, we're kind of economic loss rule, we can put that aside, don't have to worry about it? You're now entitled to go after purely economic losses?
I think purely economic losses attendant to a property damage. I'll give you what I'm going to come up with a reverse analogy, which is a game I play with myself sometimes. It's very frustrating. But let's take the A.J. DeCoster switch manufactured by Westinghouse. And instead of putting it in a chicken house, let's put it in a restaurant. And it doesn't go off, and it's a 95-degree day with 10,000% humidity, and nobody wants to come in there. So the restaurant, until that switch is repaired, suffers an exodus of customers for a week or for 2 days. But no property damage. It cannot recover the sales it did not make, because the only damage, the only injury is to the product itself.
Well, do you have, do any of your damage categories, the product was damaged. I mean, I don't think anyone disagrees with that. But do any of your elements of damage, your monetary claims, involve something that's not economic losses?
The problem, I can't.
That should be, answer it however you want, but you would think that would be a yes or no answer.
Well, and I would think it would be if we were not talking about corneal tissue, which is not a normal product. Because the damage to the corneal tissue, if we're going on, quote, non-economic damages, is the replacement of that tissue. Right? And the only way we can do that, I can't go to a store and buy this, so I have to go to the Carolinks of the world, as long as I'm doing it appropriately under the Uniform Act that's used for therapy or treatment or education, whatever, and I'd have to get it. So I would argue that the losses that Carolink suffered are equivalent to the replacement.
So that's your argument, that because we have a unique situation here of, body tissue that you can't replace like you could a shoe or something like that, then you get to kind of skip over the fact that the economic loss rule and call what would otherwise be economic losses the value of the property?
Well, to be clear, I believe that once we have damage to property, first step of the argument, the economic loss goes away. But to address your question more directly, notwithstanding my assertion, I believe that when there is damage to property, such as the chickens,
Mhm.
then you replace the chickens, whatever that cost is. When you're talking about corneal tissue, theoretically, you replace that tissue. What is the cost of that? That is equivalent in this very weird and unique market to what is, in essence, the cost. Because to replace them, we would get the tissue, and then there are significant resources invested by the laboratory, the technicians at Carolink to process to very specific FDA regulatory standards, but also to surgical standards, different types of grafts. And that's a significant investment, and that is largely, those costs are what drive the service fee that is charged.
Counsel, just for purposes of helping me to understand sort of the examples here, I thought the district court said, in applying the economic loss rule, that the property in question was not actually the tissue, because under Maryland law, Carolink doesn't have a property interest in body parts. The property at interest was actually the service fees, no?
I didn't, you may have read it more subtly than I did, and I'm going to give you a real candid answer. I didn't get that.
Okay.
My analysis of what Judge Blake read, I think I was just pleased with the outcome. But I think following up on your read of it, sure, service fees are intangible property rights.
But so that would swallow up the economic loss rule, right? I mean, that can't be right, but maybe, it seems to me like any claim for lost profits would be subject to the same assessment, or is that, am I missing something there?
I think, I don't know that you're missing anything. I think it's a very good question. I think you're looking for a limiting principle. I think the limiting principle here is the damage to property. Well, this is going back and forth between the service fees and the employment issue. I don't believe, by the way, Judge Harris, that the court said that there was no property interest. Couldn't be.
I think that's
She said,
right.
as I recall her analysis, is that there are property interests that are appropriately limited.
Right, and so I thought what the limit was that in this case, your property interest is the interest in the service fees.
Okay, see, I didn't, that's the
Okay.
leap I didn't.
Okay, I may have
I don't
misread
mean
it.
to say it's a leap.
No, I may have misread it.
What about the employee time? You know, nobody seems to be concerned about that in this case, really arguing it much. But it seems to me that that's the red flag of pure economic loss, isn't it?
Well, it is if we're going to divide this up. I'm advocating, Your Honor, for there is a trigger.
I mean, that's really not the point they're making.
It's not the
And
point
so
I'm
I'm kind of going out on a
I wasn't going to make it.
hunt myself, but I'm interested in your reaction to that.
Well, my reaction to it is what I articulated early on, is that if you have a defective product that does not damage property other than itself, then you are left, other than replacing that product, giving the consumer benefit of the bargain, you can't get anything else. But when it does in fact injure property, then I think it triggers the elimination of the economic loss rule. I believe that's what the Court of Appeals of Maryland means when it talks about purely and solely.
So what you're saying then, if I get this correct, is that the Maryland Court of Appeals is saying that if the only damages sought in this case were employee lost time, that would be unrecoverable, per se. But because it's in a basket with other recoverable charges, if we hold that the service fees are recoverable, then the entire basket of loss is recoverable. Is that what you're saying they're saying?
That's what I'm saying. I think you said better than I did, but I agree. This basket, once you put property damage into that basket, along with economic loss, as long as there's property damage and damage associated with that. Yes.
Can I ask maybe a basic question? You don't have to answer this because it may be legal strategy. So please just say, I won't hold that against you at all. But it seems like you got a fair, I mean, I know it won't be conceded, but a pretty clear implied warranty claim against Stratus. I mean, they're not, and you know, in joint and several liability judgment against Stratus on the, you know, implied warranties, you know, they're fighting about, you know, strict liability and express warranty, but why, you know, why do you care? I mean, you're doing a lot of gymnastics and stuff like that. What's going on?
That's my candid answer to my litigation strategy. Affirm just one of the judgments, and I'm happy as a claim.
Right, but the district, and that, it seems to me is that possibly a question that arises from the final judgment. The final judgment, to borrow a word from the previous case, aggregates the damages. It doesn't parse them out with strict liability, implied warranty, express warranty. So, and holds Jarcare and Stratus jointly and severally liable for the amount. So is it your position then that if we affirm on strict liability, the rest doesn't matter?
Yes, I'm trying to think that.
Okay, and tell us why.
Well, retreating from my more jocular comment, the judge in response to, I'll take any win. What we have are different ways of dressing up, slightly different elements, but the same essential claim. And the damages that flow from that, whether you get to those damages through strict products liability, through breach of warranty. And there is a finding by the district court as to each of these defendants as to strict products liability and as to warranty. It's a different warranty with respect to the two different,
Right, but I'm saying here we have one judgment. $606,000. So tell me whether it matters, the different theories of recovery, if one of them succeeds against both defendants, Stratus and Gericare.
If strict products liability survives
Mm-hmm.
as to both defendants, then I don't think it matters. I think you have a joint and several judgment.
Okay, why is that?
Because ultimately, their actions, albeit different, one being predicated on a breach of this express warranty, well, that's not true. They're both under the same rubric. Their actions individually combine to cause the same injury.
Can I ask you a question, one level higher in the outline about what matters? Am I understanding right that there's the economic loss problem, there are sort of, I'm not sure this is exactly the right way to think about it, but two exceptions. One is this property damage exception on which the district court relied, but the other one is this public safety exception. And there's a lot of law on that in Maryland, and it seems pretty favorable to you without sort of getting into it or anything. Why, wouldn't that have been the more straightforward way to resolve this issue?
Well, I argued it.
Uh-huh.
Judge Blake, for her own reasons, decided that based on property damage, which I think she believes is clear,
Well-
solely in the
Well, don't you think she also did possibly to avoid the possible choice of law issue? I mean, she mooted the choice of law issue when she didn't rely on the public safety exception, didn't she?
Well, I think she may have.
Because essentially, if there was error, it was harmless because there was nothing different about Maryland law regarding economic loss.
I think she figured correctly that she didn't need to go there. I agree that it's much more straightforward, but she did, ironically, in the context of strict products liability, discuss the risk to human health posed by this. Now, the standard, by the way, of risk to human health, and I'm using the vernacular, not the correct words, but under strict product liability versus economic loss doctrine, I think there may be a level of urgency associated with one that may not necessarily be appropriate with the other, but they're certainly very close.
But that issue, the exception Judge Harris is talking about applies under Maryland law. So for that to be the basis of affirming or for that to be the basis of saying the economic loss rule doesn't apply, we'd have to affirm on the Maryland choice of law correction or decision, correct?
Well, I don't fully agree. There are other jurisdictions that were raised.
Which one has that exception?
I think the District of Columbia does. I cannot recall, candidly, trying to juggle so many laws.
Okay.
But I think a number, and I'm not going to characterize it beyond a number of the other jurisdictions recognize that.
Can I direct your attention to choice of law a little bit now? It seems like under your theory that the choice of law in the district court's decision about the choice of law is determined where the economic effects of the contamination are felt. Don't worry if I said that a little bit wrong, but doesn't that essentially say the plaintiff's residency or the place where the plaintiff is located is always going to be the place where that state's law is going to apply?
I can't say that that's always. I think in a small business context, and this is notwithstanding its presence in a number of jurisdictions, this is a small nonprofit business where all of its ordering is centralized, where all of its contracting is centralized, where the normal last acts, in tort law in Maryland at least, the last act necessary to give rise to liability in tort is injury.
Right.
Where do you suffer the injury? And the injury here, as well as the financial fallout from that. But all of the significant actions, whether under the warranty theory or the tort theories, are all centralized in Maryland. Now, the happenstance that that Caroling has a number of subsidiary procurement agencies or people in different states where they gather the donated material and then expose it for the first time, packaged up, processed, and sent to Maryland, I don't think changes that. I don't think the injury is complete.
So if I live in South Carolina, and if I own rental property in Florida, and I have some heater that I buy to heat my, or storage property in Florida, I buy some heater to keep it warm in there, and the heater is defective and everything catches on fire. And all that it does that and it burns it down. Are you saying that because I live in South Carolina and that's where my kind of finances are, that's where the tort's completed?
I think I missed the first part. Is the defective thing in your?
I buy those storage units that are everywhere in Florida, and I have a heater in there, and it's defective and it catches everything on fire.
No, I don't believe in that instance.
What's different?
Well, the difference is what jurisdiction has the most significant interest in that. Florida.
Okay, well, that's a different test. I mean, the question, I mean, if we want to apply most significant interest test, we can apply most significant interest test. But under Lex Loci, what you have said is the place where the tort is completed is Maryland. And I don't understand how my situation is different from that in the Lex Loci place. I understand if we're talking about most significant relationship.
Okay, I'm sorry, I just went off track a little bit. I mean, I would argue that what you've lost in Florida are your chattels, whereas the locus of the injury for Caroling is its accounts, its ability, its product gathered in Maryland may have been processed elsewhere, brought into Maryland. The 182 corneas and the other, that's actually stratified. The several thousand corneas that are sitting on its shelves, refrigerated shelves, that it cannot and may not use and must destroy. So, again, the problem paradigmatically all through this case in trying to talk about concepts of tissue and analogize them to other areas of law make it very difficult for me. All I can do is respond as best as I can.
Thank you very much. I think, Ms. Giroux, you've got rebuttal time.
I disagree with the concept that in a case like this, a plaintiff can bootstrap economic losses that normally would not be recoverable because of the economic loss rule, simply because there has been damage to property other than the product itself. That does not give them a blank check and open license to claim all of these purely economic losses. If so, why would the court in A.J. DeCoster go to the trouble, in its opinion, of segregating out, here's what you can claim and here's what you can't claim in the context of those chickens? That's what the court did, and I haven't heard from Caroline in this case. To me, that the eggs that were lost by those chickens are analogous to the loss of the tissue in this case. And just like in A.J. DeCoster, the court says you can't get the lost profits from the loss of those eggs. Likewise, they can't get those lost profits from the loss of the tissue in this case. It doesn't matter that the tissue is damaged. Even if you believe that it was property, they still can't bootstrap all those other damages. Then the better analysis would be to analyze the damages to see which are economic losses and which are recoverable losses.
On that point, what are there any losses? I'm trying to figure out, are there I mean, we've talked about the employee costs, we've talked about the fees. Are there any other damages?
I believe that there are damages having to do with storage, disposal, just those type of process damages, all of which are economic losses.
Okay. Your position is every damage sought here is economic in nature.
Yes. They're not claiming replacement costs for the tissue, and I don't think they can do that under Maryland law. That's not what they're doing. They value the tissue based on what they would have earned through the services that they provide, the transportation, the disposal, all of those services relating to the implantation of the ocular tissue, not to the tissue itself. It's not like the chickens. This is separate from that. But just because this is an unusual situation does not warrant us completely rewriting the economic loss doctrine in Maryland. There's no reason to deviate from what the court held in that A.J. DeCoster case. I would like to close by just focusing in again on the sealed container defense in Maryland and how this shields my client Stratus. The eyewash was obtained in a sealed container. Stratus was not aware of any defects, but had no reason to suspect any defects and relied on the representations and the warranties provided by GeriCare. Stratus was exercising reasonable care and couldn't have discovered any contamination from visual inspection. Stratus did not manufacture, produce, design, or set forth specifications like what GeriCare did in terms of the GeriCare eyewash. And Stratus did not alter, modify, mishandle in any way this product, in any way that was the proximate cause of the damages here. It was all the mishandling by GeriCare of this, what should have been sterile eyewash. It was represented to be sterile eyewash.
Counsel, what's your defense to the implied warranty claims against Stratus?
So I try to break it down into the elements and look at the basic elements of an employee warranty claim. First, the existence of a defect. I would question whether or not there is an existence of defect. What Stratus was required to provide, asked to provide, its agreement with Carolyn, was to find and get them eyewash, sterile eyewash, and put it in the custom striping packs. That's exactly what they got from GeriCare.
So you're saying if you pass on these packs with contaminated eyewash for use in this process of extracting and doing transplants, you've not breached the implied warrant of merchantability or fitness for a particular purpose?
Our obligation and what we did was get eyewash, sterile eyewash that was sealed and in a sealed container.
Why do you say that's your obligation? Doesn't the law imply that you also have an obligation to make sure the product is fit for its intended use?
And that's exactly what.
Well, how is it fit for its intended use if it's contaminated?
They went into the marketplace. They found FDA-regulated
Sure.
sterile eyewash that was in a sealed container that was identified as sterile eyewash.
But why isn't that a fight between you and I know y'all got a fight. That's a great argument in your indemnification contribution claim, but how does that matter now?
Your Honor, we do, of course, have that fight. But that therein lies is what I view as the real defect here.
I got you.
Is that what is the product that we got from GeriCare was not the product that we should have received. Now, the attribution, the second element, attribution of the defect to the seller. Again, we were not involved in any way in the manufacturing, packaging of what should have been sterile eyewash. We were in no way responsible for the eyewash not being sterile. And finally, that causal relationship
Thank you very much. Again, we are sorry that we can't follow our normal custom of coming down and shaking hands, but we do appreciate your help today with these cases. And we'll ask the courtroom deputy to adjourn us for the day.